Sorry, Mr. Chairman.
My Lords, I'll now turn to the H2 judgment, which you have at tab 10b of the core bundle. My Lord, if I just ask the Master of Rolls, you said you've got it separately. Would you therefore want the internal page numbering? As
The internal paragraph numbers would help me.
Same for me. Yeah.
Yes, will do. Now, I've said that I'm going to approach this in two steps. First, I'm going to look at the dishonesty and the side agreement issue and the way that this affected the tribunal and how it thought about those in relation to the issues it needed to decide. And then I'll turn to the way in which it came to uphold, nonetheless, the CMA's conclusions in this judgment. So I begin then with the dishonesty and side agreement side of the case. If you go in the judgment to paragraph 7, which is on page 402 of the bundle, internal page 7, you'll have a heading, the findings in the hydrocortisone decision. These are set out in paragraph 7 that follows. Paragraph 7 extends over 6 pages and 10 sub-paragraphs. But this is what, in the tribunal's view, is the gist of the CMA's decision. If you look in this at page 403 of the bundle, internal page 8 at the bottom, you'll see sub-paragraph 5, which has Roman 1 and Roman 2. You'll see in Roman 1, the tribunal says in the penultimate line on that page that the substantial monthly payments to AMCO represented by the supply agreement and under value were, and it underlines the word, disguised. And if you follow the footnote through, the tribunal comments that in comments on the draft of this judgment, the CMA suggested this wasn't a finding that it had made. We disagree. Look at this basis of disagreement. The decision finds there were inflated payments for product to which it attributed a purpose other than simply payment for the product, which was nowhere expressed. By inflated, I think it means payments of undervalue. But the key point is here that it is true that the CMA says that this was the vehicle for making the value transfer, but it was not making an allegation of this being deliberately masked or concealed. And that was what the CMA sought to get across in its comment. But what you see from the tribunal's judgment is it underlines the term disguised, and then over the page, Roman 2 at the top, again, in the parenthesis, second line of Roman 2, effectively disguised as supply agreements features. So the idea that there's a deliberate cover-up is important already for the tribunal's approach to the case.
So you say the decision didn't say they were disguised?
That's right. It doesn't use that word. What you've got is, my lord, the word sham and the explanation of the word sham that you've seen in, I can't remember the paragraph now, 6.922 maybe. So that's right. Now, in the following sub-paragraphs, where it's digesting what the CMA found, the tribunal takes this point further and it culminates at sub-paragraph 10. That's the final sub-paragraph, bundle reference 406, internal page 11, bottom half of the page, and it goes over to the next. Yes, so it's sub-paragraph 10. Now here is where the tribunal quotes the part of the decision dealing with the word sham. And I've taken you to this in the decision itself, but in the 10-point type, you have the representations of AMCO and Sinvan about it, and then the response of the CMA underneath in the paragraph beginning the description of the side supply deals as a sham simply means. So you've seen that. The thrust of the tribunal's reasoning is that according to the CMA, it decides the way that the parties have set this up was intended to hide from somebody or other what was really going on, namely a value transfer in exchange for a promise not to enter the market independently. Now, in the first extracted paragraph here, taken from the CMA's decision, we see the CMA's responding to the company's representations about the elaborate deception. And below that, you've got...
Where are you now?
I'm looking at in paragraph 10, it's the parts we've already covered. It's the paragraphs cited from the decision in those two paragraphs.
And then make extensive representation.
Yes, yes. So in the first, it's just to underline the point that the claim made on the other side by the parties, as you see from the last line, was that they were engaged in an elaborate deception to cloak their intentions. And the CMA is pushing back at that and saying that's not what we mean. And what they say is that this supply at an undervalue, it signifies that this is a means of paying AMCO, not simply giving AMCO product to sell in an ordinary distribution deal where you're essentially paying them an amount to remunerate them for a distribution service. Turn over the page to page 407, internal page 12. At the end of that subparagraph, right at the bottom, the tribunal is commenting on this statement by, I say right at the bottom, I'm sorry, in the middle of that text. The tribunal is here commenting on the CMA's explanation. If you read from about 9 lines down from the top, you sit by the hole punch in the hard copy. It says, but this is not sufficient, underline not, to enable the CMA to escape the consequences of the findings that they did make, namely that some, perhaps a very limited number of human actors, must have had the common understanding that one, the first and second written agreements said less than what had been promised, agreed or arranged. 2, the agreements hid the true purpose of the arrangement, which was to pay AMCO rather than simply give its product as in a genuine bona fide distribution deal. Put another way, the decision found a common understanding going underlined beyond the written agreements. That common understanding must reside somewhere. Now, as I foreshadowed before, this seems to be the main basis of the tribunal's view at this point, that this is a dishonesty case. And there are 3 points that fall to be made straight away. And I'll be quick. The first is that according to the decision, as you now know, this arrangement started out in 2012 as an undocumented agreement to supply product on favourable terms. Just based on the shared promise or common understanding that that arrangement was an alternative to independent market entry. Second point, experience in this field of law, I would suggest, indicates there's nothing necessarily illegal about this sort of deal to businessmen who aren't competition lawyers, let alone knowing the ins and outs of snook, and who are focused on doing a commercially advantageous bargain for their companies. And you can appreciate this, the fact that from their point of view, they're not thinking that this is a dishonest or furtive arrangement. If you simply recall some of the contemporaneous documents, which we've now already looked at, discussing the bargain made by Mr. Baton in the summer of 2014. Because I'll show you again one of them. If you cast your mind back to those documents, we saw that within the company management, the outline of what does in substance amount to an anti-competitive deal is set out and discussed in very candid, very open and unguarded terms, because they simply do not recognise that this is a breach or wrongful behaviour. So let's go again to the email of the 15th of June and now look at it in the original version, my lord. So you'll find that in the supplemental bundle, supplemental bundle volume 6 at tab 26 on page 2400. Now you can see it more clearly from the original because you've now got the circulation list, you can see it in context. Court has that. That's page 2400. So you can see at the top, it's an email from Mr. Bayton to a range of his senior colleagues. Got Miss Hill, Mr. Van Tiggelen, Mr. Sully, Mr. Clark. And Mr. Bayton has no qualms about telling those colleagues, including the General Counsel, that he's revealed to a potential competitor his commercially sensitive information here. Having said that, I went in with 12,000 per month when I knew that Jane had forecast 10k per month. He's giving that information away, saying how many packs he can launch on the market independently to establish what he's going to need to be compensated for in a supply agreement. And then just below that, he's got no qualms about telling his colleagues too that he's used the threat of launching his own product as leverage to exert pressure on Auden to do the deal. Instead, there isn't a cover-up from anybody. This is viewed within the business as essentially it's a hard, fair commercial negotiation. And there is nothing treated as secret or covert within the secret management team, therefore, about this arrangement or the arrangement to cancel their own Ithaca project for bringing a competitive product to market because of the profitable new supply arrangement that's been struck. We looked at those documents earlier. You saw their reasoning about why they were cancelling the Ithaca own product project. And the only thing that they wanted to keep secret was not telling Ithaca, the contract manufacturer, that it was because of the Auden deal that they were not going to proceed. Third point, and my last point, by way of framing this, it must be underscored, again, this is not a situation where you have two businessmen meeting and deciding to draw up a document from which they omit key contractual terms while pretending to the world that it's a complete document. The arrangement between Auden and AMCO had been in place for more than 1.5 years. What happens in 2014 in the summer is that earlier in the summer for this, AMCO responds to advice from its solicitors that the existing supply agreement has to be formalised, documented. And that then happens, and the context of this documented supply agreement is the understanding by the businessmen on both sides of the table that it's a substitute for doing battle on the market. But it's entirely realistic in my submission that no one even thought of that as giving rise to some binding obligations on staying out of the market, which had to be documented or set out in their own right.
Your position is it doesn't matter whether they did or they didn't have that view. It really.
Yes.
What does the CAT mean by dishonesty? I mean, it has quite a technical legal meaning. If you look at Ivy, for example, it has the subjective and an objective element. How does that apply in the CAT's eyes to the facts of this case in relation to this witness? I mean, and how does it then have legal resonance? I mean, it is now quite a technical term which applies in the context of certain statutory offences.
Yes, it is. The term dishonesty, and I understand and agree with that comment, is not elaborated by the tribunal, so it doesn't specify what it entails exactly, whether it involves some deception of a particular person. It appears at most to involve this cover-up, but the only specificity that one finds about dishonesty comes not in relation to what it involves, but to its consequences, as we'll see in a moment. The first of which is the statement that it may involve a heightened standard of proof, is mentioned at one point. But there is no...
You could get that in a cartel anyway because it's quasi-criminal and penal. That's often said you need a vigorous standard of proof before you find an infringement, simply because the consequences are grave. And it's often described as quasi-criminal.
It is.
So what's the difference between it being a fraud case or a dishonesty case and just a quasi-criminal cartel case in terms of the standard of proof? I mean, there's two things which appear to be elided. One is the test for breach. Does it involve dishonesty? And secondly, in the context of cross-examination, whether one should have put that he was a liar as a question, but the latter goes to the probative value of his evidence. The former is whether it's a substantive part of the breach. I'm not quite clear in what context the CAT is using dishonesty here. Does it really just go to whether they believe his evidence or not? Because they've already said he's a liar.
Well, it seems to go to both, doesn't it?
Maybe
At
both.
different stages of the
Yes.
judgment. They don't really distinguish between dishonesty as an ingredient to the relevant tort, and dishonesty in the sense of having lied to the tribunal in the evidence.
We agree with that. What one sees, and we're now going to just work through to see what one can get from
And the
these.
short answer on the first point, you say it's not a necessary part of the not a necessary ingredient at all.
That's right.
And on the second part, you say, well, you didn't need to, or Mr. Dimitri didn't need to put to Mr. Baton that he was lying in circumstances where he was taken through the whole of the CMA case. And if we look at this email we've just been looking at, she wouldn't have needed to say to him, you're lying to the court, because he accepted when she put to him, that's, this is what you were saying, that if you don't supply us at such and such a rate, we'll come onto the market ourselves. And he says, it looks like I did say that.
Yes.
I mean, she might, I suppose, have pressed him harder at that point and said, well, come on, Mr. Baton, it's a bit more than look like, isn't it? That's absolutely what you were saying. Some counsel would have done that, some wouldn't. But the thrust of the point was there.
Yes, and I shall take you to this to show you that he does effectively say, yes, that's the implication, I'm just not saying that. That's enough.
Yeah.
In answer to my Lord Justice Green's point then, and to round that off, we agree. There are those two strands, dishonesty both in terms of, is it an essential ingredient of the underlying events?
It's not really a tort, is it? Because we're not
No,
looking
it's
at
not
damage.
really a tort.
It's a statutory breach or a regulatory breach, however one wants to
Yes.
describe it.
And secondly, lying in the witness box. And in relation to the first of those, I also agree with your analogy to a price-fixing cartel, because the circumstances in that involve, one would suppose, no less a question of dishonesty in the sense that the tribunal appears to have in mind here, something done without broadcasting this to the world at large. But again, one would not say that in that ordinary, more common type of case, that one would therefore need to engage a much higher standard of proof and allegations needing to be put to the witnesses that they are behaving dishonestly. Again, if one thinks about the implications of this judgment, it does have that consequence.
The other thing which puzzles me, in the second case, H2, they make a finding that the anti-competitive object was flagrant.
Yeah.
I mean, it's not marginal. And that's on the basis of the evidence they did hear. So coming back to my Lord, the Master of the Rolls question this morning, if it had been put to him, you are a liar, aren't you? And he said, no, of course I'm not. Well, they decided he was a liar. What would that have added to anything? They found a flagrant violation
Yes,
by object.
they do. And again, to stick to what the law requires, to find that there's a flagrant violation by object is a focus on the nature of the agreement itself, not the subjective intention of the people making it. You just look at what it does, and if it's paying people cash to stay out of a market, that is a flagrant breach of the prohibition, having as its object the restriction of competition.
But that was on the evidence the CAT did hear, which
was.
included the witness evidence.
Yes.
And there's a straw man here, isn't there? The CAT, and we're going to take this, the CAT comes to the conclusion that Mr. Bacon had lied in his evidence, and then says, well, it was never put to him that he lied in his evidence. But if that was something that was troubling them, there are ways in which one would think about that as a judge, certainly. You think, well, hang on a minute, I don't really accept that witness's evidence. It doesn't seem to me to be right. And you think, well, was he lying? And you think, well, nobody actually said he was lying, in which case you'd say, well, I don't accept Mr. Baton's evidence, he must be mistaken or misrecollecting or something. There are ways in which you could sort of dress it up, in which case none of this stuff about dishonesty or lying would be amount to a row of beans.
And that's exactly our point.
And this is really it's the CAT itself which has set this up as the.
But the judge seems to have thought there was some kind of self-denying ordinance that prohibited him from saying, look here, Mr. Baton, it appears that the CMA is saying you're not telling the truth. What would you say if you'd been asked that? Because there's nothing wrong with the judge doing that. If somebody goes to the edge of a question and doesn't ask it, at the end the judge can come in and say, well, hang on, the elephant in the room is this, and if he'd wanted the answer to that, he could have done it. But he thought he couldn't.
He thought he couldn't. He said he would be descending into the arena.
That's right. But I want to ask you another question, which I think is just quite important, bearing in mind the case put by the other side. The CMA, you've said the third point is, this is not a case where a document was drawn up omitting a critical term. Right. But the other side placed great reliance on the fact that the CMA accepted that the written agreement was lawful. Right? Now, why do you accept the written agreement was lawful when a term of the agreement is they won't go into the market without telling them? And the 3-month period, that is the period within which they've agreed not to go into the market, and they're being paid a massive value transfer for the supply, surely makes that agreement unlawful because it records the critical terms that include we won't go into the market. The fact that they can stop it at 3 months' notice doesn't really make any difference. They're being paid for not going into the market. So why did you accept that the agreements were lawful in themselves?
Thank you, my lord. Let me clarify that. First point is that the CMA did not say these agreements are lawful.
Okay.
He never said that.
You never said that?
No. Its position is that these agreements, essentially, the supply agreements, they don't fall to be examined in isolation from their context and the wider understanding in which they fall. From a competition lawyer's perspective, you take into account all of this wider context in deducing what the agreement is. There is not and never has been any statement by the CMA, we find that these agreements are lawful. The thrust of the CMA's...
That's what the cat says.
I know. Well, yes, they say that at one point, and at another point, they recognise the true position, which is that the CMA did not say that these agreements, they didn't take a position on them being lawful or unlawful. It's like a doctor looking at your hand to say if you've got a cold. They were a part of what was going.
Hang on, I don't get that. No, the doctor's looking at your hand to see.
Well, it's like the hand is the part of the body. The body is the wider agreement. The written agreements were really the vehicle, a part of the arrangement, because they were the means by which the value transfer was effected. But in the eyes of the competition authority, you don't look at that by itself and they say, well, that bit's lawful. You're concerned to look at a wider arrangement to try to see if there is...
Well, I get all that, but the other side say, in terms, that it's common ground that these agreements were in themselves lawful.
No, it's not.
It's not true.
No, because...
Where's that in your skeleton?
Well, I look for it. Thank you.
And more pertinently, where does it come from? If there is a misunderstanding, what was it that you said which might have given rise to that, if anything? I mean, how does that statement come about?
The way that... so in my respectful submission...
It goes back to the side agreement point, doesn't it? Doesn't it go back to the side agreement point?
It does.
The CAT's interpreted as being a case where there's the written agreements which are in themselves unobjectionable, and then there's a side agreement which is the real deal, and it's the real deal that is objectionable. And your point, as I understand it, is that the written agreement is not to be looked at in isolation. It's only a part of the whole overall agreement. The whole overall agreement was unlawful. That's your case.
That is our case indeed. Yes. If I may just respond to my Lord the Master of the Rolls, I've got some of the references here straight away. Thanks to very helpful juniors. I'm reading this as well. In the core bundle 1168.
Paragraph
6.899.
What is 6.8199?
6.899
Within the
in the decision is part of the decision.
Which page was that?
I'm sorry, it is page 1168
Thank you.
in the core bundle, the second volume hard copy.
899.
6.899.
I see. It's not the agreements in themselves.
Yes, yeah. Well, exactly. And so to then respond to what my Lord Justice Green said, well, how on earth then has this come into the picture? And I'm afraid to say that is probably just because in adversarial litigation, people put positions, other people deny that this is what was actually done, and the court or tribunal will then take a view. You're absolutely right that this was put, and it remains a feature of their case that they say your analysis, CMA, is that you start with a lawful supply agreement. From that premise or that starting point, you've now got to try to work out where the additional mischief comes in and how that comes into the picture. So they essentially...
That's, I mean, 6.899, or 6.898 and 899 taken together.
Yes.
Making it, this is the CMA making the point that the submissions that were made on the basis of the written agreements alone ignored the counter-performance.
Yes.
The counter-performance being the fact that Auden was selling this stuff at what if it was £1 a pack when it was actually retailing. Is that the point that's being made?
Auden was requiring payment to it.
Requiring, yes.
Yeah. Of that at a very, very low price.
At £1 or £1.78 or whatever
Yes.
it was.
Well, I think the problem is the counter-performance means staying out of the market. And
I'm not sure it
the problem is that this is 6899 is redolent with ambiguity. It is saying it's not the supply agreements in themselves that are anti-competitive, but the truth is, on the analysis I put to you, they are anti-competitive without more, because you're paying to stay out of the market. Now, I know they're hedged about with conditions that might make that much more arguable than an absolute undertaking not to enter the market. But nonetheless, that seems to be where the ambiguity comes from. And I would like to see in the judgment where the tribunal makes the same point, that the agreements themselves are, according to the CMA, not unlawful by themselves. Where's that in the in H2?
So look, if you'll allow me to go through, I'll show you this. But my lord, you're absolutely right in what you first said about this, which is that the tribunal does, at points in this judgment, say the CMA found that these were lawful agreements. Therefore, we're looking for the addition. And at certain other points, it reflects what we say is the correct position.
Your answer is hidden, and hidden equals dishonest, and dishonest is not what you have to prove.
Yes, and in terms of the agreements themselves, I think there are 3 levels that you can look at this at. If you take these agreements on their face, and you're just an outsider, you see what appears to be a vanilla supply agreement. You don't know that £1 is way below the market price. You just see an agreement that, viewed in isolation, looks perfectly legit. Second level, just below that, is if you do appreciate that context, you understand that this is a supply at a massive undervalue. And at that point, still, from a competition lawyer's perspective, there might be a supply at a huge undervalue. Maybe there's some other explanation for that. Maybe it's part of some wider legitimate commercial arrangements. You don't know. It's only at the 3rd level that competition law now comes in, because you see that, and then combining it with a range of other indicia and evidence, you say, I can now see in context that this is the vehicle for a value transfer which is buying off competitive entry. That's how the analysis ought to run. And the error is in starting with this, on its face, simple supply agreement and saying, well, the businessmen sat down and they concluded that they must have covered up these additional concealed side agreement terms. And if you ask yourself about this decision to transfer value to AMCO by supplying it with product at a heavily discounted price, again, put yourself in the shoes of the businessman doing this deal. It too is not necessarily either deceptive of anyone in particular or dishonest in a strong sense that the English criminal law here attributes to dishonesty. It could well have been viewed by the businessmen who were sitting down doing this deal as a very simple, practical way of compensating AMCO for not launching its product. And there not being an intention to pull the wool over the eyes of someone or other. Because, again, in the same way that businessmen may not have Snoop at the forefront of their minds, this is the sort, and it's been found in this field with these other cases, such as the Lundbeck case, the ones considered at a European level. It's not necessarily deceptive to engage in the value transfer in this way. So to draw the threads together, if I may, we say that the tribunal's contract type approach to this problem, which is, here's an express written agreement, lawful on its face, there must be a deliberate hidden side agreement containing additional obligations, is based on a misunderstanding of the case that's put to them by the CMA, and, if I may say so, a misunderstanding of how the competition rules about authorities bringing to light unlawful collusion to the prejudice of the public actually are meant to work in practice. Now, at points in this H2 judgment, the tribunal does, I confess, pay lip service to the proposition that an unlawful collusive arrangement can be tacit and can involve conduct based on...
It doesn't just pay lip service, it actually says those things very clearly. I mean, you're saying that... you're saying that the judgment is basically inconsistent. I mean, you don't have to go as far as to say they don't understand competition, because they plainly do, Mr. Turner. They simply... What they've done is fallen into, you say, into an error of thinking that this particular case was a particular kind of dishonesty that had to be challenged directly when it wasn't. That's the misunderstanding. They get that you can have a tacit agreement. They get that other cases can be fall into a different category, but they've somehow thought, you say, that you don't have to go so far as to throw the entire baby out with the bathwater. You can just get rid of some bathwater. You just say they got it round their neck, sort of right at the end. They got it all right. It's a bit like the right notes in the wrong order. Every note is there. They understand all the rules that you've been submitting in the rules. But at the end, they seem to have become, you say, over-concerned about dishonesty, which is not part of the complaint.
My Lord...
Don't have to go further.
Yes, no, my Lord, that's a fair correction. I'm not saying that this tribunal does not understand competition generally.
Plainly
do. No, but what I am saying is that in the circumstances of this case, the way that it applied the law to the facts is based on a misunderstanding of how it's meant to work. This choice of the lawful agreement. So I fully take your point, but that's how we put the case.
Yeah.
Now, to follow that up, I want to show you then that the tribunal's approach to analysing this central issue in the case is misguided. How it did it in this particular case.
Yeah.
And I will say that this is not a case of an express written agreement deliberately omitting key terms with there being a side agreement.
Yeah.
So if you stay on page 410, which is internal page 15, here, look at, this is an interesting analytical point made by the tribunal on this issue. What you see is that in 10.1 and 10.2, the tribunal is distinguishing overt infringements, for example, the multilateral interchange fees that this court knows about, and covert infringements, like cartel cases. And the tribunal says that if you're dealing with the second type of case, and we've been canvassing with Lord Justice Green how one approaches a standard cartel case, there they say that it's different from the overt case and you've got to approach it in a different way. So in paragraph 11 over the page, having set out the distinction between these two different types of thing, an overt and a covert case, the tribunal makes the point at paragraph 11 that essentially we're classifying this one as a covert collusion case, akin to a price-fixing cartel, and that's one where conspirators take great care very often to cover up their tracks, and says that in this sort of case you've got to exercise an extraordinarily high degree of care in finding the facts, almost by contradistinction to the first type of case. Now, I have already made the point that actually, when you look at the way the businessmen related to each other and discussed what they were doing, this isn't that type of case. It's not a covert cover-up. It's not a case where people concealed their tracks. You've seen the frank discussion in the company at the time about this negotiation. You've seen the unashamed statements that this deal is an alternative to independent entry. And you'll see that at the trial, in his evidence, Mr. Baton doesn't demur from that. As I've foreshadowed, he takes the position in his cross-examination by counsel that the implication from the threats on his part, which he very candidly admits he made, was that the supply deal's the alternative to a launch. And as I've already said, his only comment, which I'm going to show you, is, well, I never actually said this. I never stated a specific commitment not to launch my product under any circumstances. Perhaps now is the convenient point, because we've been talking about it a lot, to go to that aspect of the cross-examination. At this point, I realised that my...
Oh, you were going through the Cat 2.
Yes. Now, I'm at this point, I realised that my file has been left in the room outside. The markings
Right,
up.
well, why not do what you said you were going to do, which is go through the judgment. And come
Well,
back to the cross-examination.
because I will show you, well, I will do that. But I'll show you just these two parts first anyway, because I think...
What are juniors for, if not to go and get your files?
Juniors will remember what it was you were going to say and tell you.
Yeah, thank you very much. So, if you have the cross-examination, I will defer taking you in detail to those bits. But I want to show you these central parts that we've already been canvassing.
Yeah.
So on page 577...
Of the supplementary bunch.
Sorry, 574 because of the 577. You start at line 3. You've got the President's question. And the President asks, I appreciate we're moving into the realms of what's for you and what also...
We're obviously not on the same page.
Right. So it's internal page
574,
56.
yeah.
Internal page 56, bundle
Yeah.
number 577.
574.
574.
577 in mine.
You see
574 in the paper.
that they were updated and you're going to have potentially inconsistent references.
No, I can't understand.
It's either 574 or 577. In the one that you should have, it should be 577. However, You can test that because it should begin at line 3, the precedent. I appreciate that.
Yeah.
Got it.
Right. I appreciate that we're moving into the realms of what's for you and also for me, speculation. But does that answer give us some insight into why this wasn't an odd or nonsensical bargain on the part of Auden? Answer to the witness, I guess at that stage it was starting to look more sensible for him, but the piece that's missing is that there was not a commitment from me not to launch our product under any circumstances. And we for sure would have done. I never, even in the early days, I never said to him that we would not launch. And actually, note the next words, apart from the threatening behaviour, there was definitely never a kind of quid pro quo that has been alleged by the CMA. There just was not. So you see two things there. First, apart from the threatening behaviour, apart from that, how was the opera, Mrs. Lincoln? He's accepting that that was something which operated, but he says there was definitely never a kind of quid pro quo that has been alleged by the CMA.
Well, what he's trying to, the line he's trying to take, and he does it in various places, doesn't he? Is say this was all a bluff.
Yes.
It's the same point. Okay, I threatened him, but it was just bluff.
Yes.
I'd never have done it. I mean, that's the line.
Yes, but what he is saying here is clearly that he engaged in the threatening behaviour. Whether there was something behind it, in the sense that he actually did have a product which was launch ready, you've seen that on that, or not. What he admits is that to get the deal over the line, he made the threatening behaviour. And his point is, apart from that, I didn't give a commitment. You can see the way that he's positioning it is I didn't say it, but it was just, as it were, the implication. And if I can take you to one more part of this on that, it should be page 547 in your bundle. Internal page 26. So some of you might have page 544, it should be 547. And now you have Mr. Mitru's question, beginning on line 6. So the premise for a negotiation like this, Mr. Baton, is that if Auden agrees to supply AMCO, then AMCO will not enter the market with its own product. Yes? That is the premise of your negotiation. You are doing this instead of selling yourself. I'll pause there because that is putting the CMA's case. Answer, yes, but I am not saying that to him.
Well, actually, the word selling is wrong. You're doing this instead of manufacturing.
Yeah, manufacturing, but then also selling it onto the market.
I know, but it's a bit confusing. But anyway.
No, I understand. It's a contract manufacturer. They get it from the contract manufacturer, then they sell it onto the wholesalers. Yeah. But the key point is, she puts to him, what is the essence of the CMA's case? Answer, yes, but I am not saying that to him. So you can see the line he's taking, but you can see also, yes, of course. Mr. Baton's evidence under cross-examination is in line with the CMA's case concerning the contemporaneous documents, which I've taken you to in the decision. There's an understanding within AMCO and by Mr. Baton that supply from Auden at the right price is the alternative to launching its own product, manufacturing it, selling it. And he conveys that impression to Mr. Patel. Mr. Patel responds by giving him the satisfactory value transfer. And in a sense, these two extracts are key to appreciating that point, and particularly counsel's cross-examination. Now, the search, though, for a secret side agreement starts up a thread of reasoning in the H2 judgment, which culminates in a concern that there's a case of dishonesty, cover-up, which has not been properly put to the witnesses.
I mean, interestingly, I'm just reading on, the bottom of page 27, top of page 28, going back to your point about what is necessary to show. But you were telling him that if you did not do this supply deal, you come onto the market, you can contest 100% of the market, which is what Mr. Clark is answer. I do not think I ever told him that, but clearly that was the implication of this.
Yes.
Well, it's even more explicit in the middle and bottom of that page.
Yes, that's it. That's
giving him the impression we had some alternatives.
Yes.
Which he says, yes, of course.
Yeah.
Yes. My lord, I'm grateful. Yes,
yeah.
That is it. And I'm sorry, my Lord Justice Green, if you're referring to lines 22 to 24 at the end.
Yes.
Yes.
Yes, absolutely.
Yes.
But he's emphatic, yes, of course.
Yes.
Yes, no, absolutely right.
So he's not denying that he made the threat, and that was the implication of what he was saying. He's just trying to say, well, it was a bluff because we didn't have any product, but that wasn't the point.
Or he's saying, but I never said it to him. I never said I will stay out of the market.
Loud, but the implication was.
Yes, but the implication was that if you want me to stay out of the market, this is what you have to do.
Is this bit put into the judgment?
No,
Not at all?
no,
Not even, but I never said that to him?
that's right.
Sure?
Well, now you're making me doubt myself, but I'm fairly sure the answer is no, because it's simply not there.
I just want you to know that technology enables me to check very quickly.
Okay. No, my lord, what happens in the H3 judgment, which we're coming to, is that the tribunal refers to various parts of the cross-examination after there has been a debate prior to that about the dishonesty question, where parts of the cross-examination about dishonesty were debated at that point. But by the time of that judgment, as I'm going to show you, the spotlight is on failure to put the essence of the case.
I mean, your point on, and I suppose the reason for showing us these passages now, but page 56 and then page 26 and 28, is that they are sufficient in and of themselves, because they effectively amount to Mr. Bacon accepting sufficient for the purposes of the CMA's case.
Yes, at this point.
No need to go any further.
At this point.
I mean, that may be the case, but I'm right. Paragraph 110 in the third judgment, he does cite this particular passage.
110.
Oh, I'm sorry. Yes. Okay. Yes,
because the word premise is misspelt in the transcript of the
I
judgment,
understand.
which is why I remembered it.
Yes. No, my lord.
It annoyed me.
No, I understood. It is certainly not. I don't know if you've managed to check the H2 judgment.
Yes, it's not there.
It's not. It's not that. So, the search for the hidden side agreement, which is in the tribunal's mind in my submission at the time of the H2 judgment, that culminates in these concerns about whether a case of dishonesty has been properly put to the advance witnesses. Not specifically have you put the essence of your case about the common understanding, but a case on dishonesty. If you go to page 412 in H2, internal page 17, and look at paragraph 14, you see an important statement, because the tribunal says, this is the H2 judgment, the critical question, therefore, is what arrangement, if any, subsisted that went beyond the terms of the first and second written agreements.
So which paragraph are you reading?
Paragraph 14 in the middle of that page.
Yes, got it.
412. This is what the tribunal at that point isolates as the critical question essentially in the case. It goes on at the foot of this page to introduce this concept of crossing the line from the law of estoppel, that a representation from one party to another must be found, which crosses the line between them.
Well, and the law of rectification.
And rectification. And may I say, we have no problem in principle with the tribunal drawing on English law to point out that there must be coordinated behaviour for there to be an unlawful arrangement in the eyes of competition law. But in my submission, it's not an advance on the way that the European Court has put the matter in the Bayer case, paragraph 102, which I've already shown you, the manifestation of the wish of one party to achieve an anti-competitive goal, constituting an invitation to the other to fulfil the goal jointly, whether expressed or impliedly.
I mean, it's not really very complicated. I'm not sure one needs all this great citation of authority. You just have to work out whether they understood he wouldn't go into the market in return for the money.
Yes. Well, you understood that was conveyed, that was conveyed between them.
Whether they both understood that was what was going on. Nudge, nudge, wink, wink. You get it, I get it. If I go in the market, I'm not getting all this money.
Yes. Right.
£21 million.
Clearly that was the implication of this.
Yes.
As he put it in that answer at the top of page 28.
I mean, you know, you can over-complexify stuff like this, which is really quite simple.
It is.
And one of the problems with these judgments is they're so very long.
Well, yes. That is one of the problems with these judgments. My only postscript, my lord, to what you've rightly said is, again, as I said at the outset, the understanding is not what's in your heart or in your mind at the time, it's what you convey between you. That's
It's what you
convey between
of
you,
course.
implicitly or expressly.
Well, that's what crossing the line is supposed to convey.
So if we go forward then in this judgment now to the heading above paragraph 24, which is on page 417, internal page 22, you've got this important heading now. What was the CMA's case and was it put? Paragraph 24.1, below that, the tribunal says it identified in the hearing that the burden of proving a sham might trigger the heightened civil standard of proof on the CMA. And then you'll see the tribunal then refers to Ms. Demetriou explaining that in this case there's no allegation of a sham in the sense of creating essentially false documents. Go to the top of the next page, 418. The tribunal says we have some difficulty in understanding this point, and we do not consider it was open to the CMA to resile from the decision. So you can see here that the CMA is interpreting the decision as essentially a dishonesty case based on its interpretation of sham, meaning a cover-up, and that in turn meaning dishonesty. It's pretty clear from this that that's how it sees it. And then immediately below that, the tribunal refers at subparagraph 2 to the President having made clear that he regards the case as a case of dishonesty, and this affects what is called there the level of the burden of proof, the standard of proof on the CMA. And he says, surprisingly to the tribunal, Ms. Demetriou pushed back to say it's not a dishonesty case. She points out accurately and succinctly, in my respectful submission, that this is a case where you have a supply agreement and both sides understand the premise is that AMCO will not enter the market with its own product. And as you have now seen from the little extracts of cross-examination we've gone to so far, that was precisely the case that Ms. Demetriou put in cross-examination to Mr. Baton. At this point, the tribunal now seems to introduce what appears to us to be a further error, or red herring at least. If you look at subparagraph 3 at the foot of that page, and read what that says, we have some difficulty in reconciling these statements with the findings of the decision set above. We accept dishonesty is not a requirement, nor is intentional negligence. but the latter two elements are necessary to invoke the penalty jurisdiction. And the CMA's case, as here, was one of intentional infringement of the Chapter 1 prohibition. In making good this case, issues of honesty might inevitably arise, and if they do, need to be appropriately put. So
that's where you join issues. There's those lines you just simply say are wrong.
No, that's absolutely right. So to come back to the point we were making before, as well as the point that dishonesty arises from a cover-up on the facts of this case, here it seems that the tribunal is saying, well, intention, where you say this is an intentional infringement, may, probably will, its language is rather tentative, might inevitably, it says, whatever that may mean, might inevitably lead to a question of dishonesty. Issues of honesty might inevitably arise for that reason alone. And this point that, or proposition, which my Lord Justice Green articulated earlier, that an intention to do something that restricts competition itself entails dishonesty, as part of the tribunal's thinking, seems to be crystallised later in the judgment. So if you go forward in it to page 485, on internal page 90, now you have a heading.
Sorry, page?
Yes. This is page 485, internal page 90.
Paragraph 150 of the judgment.
Okay.
50.
150.
150, that's right. So just above that, there's a heading which is called Findings of Dishonesty.
Yeah.
And if I can go to the paragraph that my Lord Justice Green mentioned this morning, 152, on the next page, 486, in this case, it is obvious from the findings made in the decision that issues of dishonesty arose. Although we've already quoted Hydrocortisone, 6930, it's appropriate to set it out again. When describing the subjective intentions of Auden, Waymade and Amco, the decision records the subjective intentions support the assessment of the content and objective. The evidence shows each acted in full knowledge of the objective of the agreements, which was to make the payments and so forth. So this is interesting because it is a clear indication that in the tribunal's eyes, if you are saying that this was the intention to restrict competition in this way, that is how issues of dishonesty arise. So this is now a separate strand from the cover-up. It's the intention to restrict competition which does it. And our point is, we've now covered this, that even if each of the companies did have a common understanding, so making the arrangement intentional, it does not necessarily connote dishonesty. So that is why we say there are actually two things going on in this judgment. The first is dishonesty in the sense of a hidden side agreement. The second is if you just intentionally restrict competition, we're into the realm of dishonesty. But nonetheless, paragraph 153, immediately below, the tribunal presses on to make express findings that Mr. Baton was dishonest at the time of the negotiations, and also that he lied in the witness box. So if you turn over the page to 487, yes, top of the page, I'm sorry, this is internal page 92, I should have said. Top of the page at little a, the consequence of our analysis and our conclusions is that Mr. Baton was dishonest at the time of the conclusion of the second agreement, and he lied about it in the witness box. Say, and at B, it's necessary to be as bald as this, partly because it's the inevitable consequence of necessary findings of fact we've made, mainly because we don't consider the same applies to Mr. Sully, who also gave evidence between us. So if we step back, this shows the court, in my submission, the tribunal's process of reasoning on this issue of dishonesty. And in order to appreciate what are the implications for due process of these concerns that the tribunal has about dishonesty, for which we have the two strands, you have to go back now in the judgment to page 419, which is internal page 24. That's what I mean by it not being the entirely linear progression. Paragraph 25, the tribunal says, as you can see, we're concerned the CMA's case wasn't fully put to Sully or Baton. We express no concluded view, not least because the parties have not had the opportunity to address us on this point, nor on the implications of it, if it is well founded. So the concern is that it's not been fully put to those two individuals selected as the witnesses at the trial. Footnote that the original negotiator, Mr. McEwen, was not put forward. And if you now go back to where we were at the end of the judgment, you get the culmination on page 488, internal page 93.
I just the words in 153, subparagraph little b, necessary to be as bold as this, partly because it's the inevitable consequence of necessary findings, and necessary is text words that they've underlined. So
yes, it is.
They've made findings of fact which are necessary, and the conclusion of dishonesty is inevitable from those fact findings.
Yes.
So if those are findings of fact they think they've made, what does putting dishonesty to the witness or anything else add?
Quite.
Necessary finding.
Yes, it seems to be, because there's references elsewhere to fairness to the witness, that if dishonesty is hardwired into what you're seeking to prove, you must put to the witness this was dishonest behaviour, but I can't improve on that. In my submission...
But there is case law. I dealt with a case of almost identical facts last year in the immigration field where the dishonesty arose, but it was critical. It was the offence. It was an immigration offence. And there was a dispute as to whether or not someone's honesty was challenged. But that was where dishonesty was absolutely at the core of the offence.
Was a necessary ingredient of the offence, wasn't it?
It was a necessary ingredient.
Yes. If it's a fraud case or that sort of...
Yeah.
Was it Allah?
Allah. Yeah.
Yes, no, well, absolutely. And my Lord, I'm grateful to you because we agree.
But it's the logic of it which I find a bit troubling. If you've made clear findings of what's necessary and you conclude it's inevitable that someone's been dishonest, whether that's relevant or not, I mean, I'm not quite certain what putting it to the witness then adds.
It doesn't add anything logically to one's conclusion. The best that I can do is to, and in fairness to the tribunal, that they were saying that it needs to be put to the witness if there's an inevitable inference that they have been dishonest.
Well, it's fairness.
It's fair, yeah.
I mean, they say it's not fair to this witness to find he's a lying hand without telling him so.
Yes.
I mean, that is, you know, we're brought up with that.
Yes.
But you say dishonesty is not necessary, not essential, not part of it.
It's a straw man point that I put.
That is the straw man point. It's basically they didn't need to go down this alley.
Yeah.
That's the point. So if you then...
You're going to take us to another
Yes,
panel.
I was. I was trying to track through the process of reasoning. Page 488,
Yeah.
internal page 93. We've now got the big heading towards the bottom, questions of due process. You see that at the foot of the page. And in the first paragraph, 1571, you have the two elements referred to as the findings of sham and intention that it has set out extensively at paragraph 133 above. Now, sham and intention matches the way that we understand the tribunal to have viewed how dishonesty arises. One, sham, the cover-up. Two, intention, my Lord Justice Green's point. If it's an intentional infringement, you've been dishonest. As a side comment, the tribunal refers to paragraph 133 above. If you go back to it, it's a long extract from the CMA's decision.
Yeah.
It's set out over 4.5 pages. It doesn't refer in it to sham at all, for what it's worth. But leaving that aside, what the tribunal is doing in the paragraph we've just read is identifying the two concepts that in its mind give rise to the dishonesty concern. As far as we can discern from the judgment, it's because of those two distinct matters that the tribunal goes on to suggest at the end of 1572, at the bottom of that page and going over to the next, that the CMA has failed fully to put its case to the AMCO witnesses. That's what it says there. We've now covered in this debate why neither of those two matters, sham or intention, do entail essentially dishonesty needing to be put, the straw man. And in any case, to trail this, you are going to see now, shortly, that both of those concerns evaporate, oddly, in the due process judgment issued half a year later. But just before I do that, because there I think we have explored, I hope to the court's satisfaction, how dishonesty is addressed in this first judgment. The other part of it is the part that the CMA endorses in its conclusion, where the tribunal upholds the CMA on the merits. I need to cover that. So we start on page 452, which is internal page 57. You've got a heading, bold 4, about halfway down the page. The 10 milligram agreement as a cartel infringement, an approach to an analysis of the facts. What I'd ask the court to do, now that we've gone through the CMA's decision, is to have in mind the difference between the reasoning of the tribunal here and the reasoning of the authority in the decision below, so you can see the different approach. In paragraph 92 over the page, which is I think the right place to start, page 454, internal page 59, the tribunal says it's necessary to consider the position of both Auden and AMCO over time, third line, that is their objective market position, and their individual states of mind, just so you can underline that, as a means of informing what common intention might have existed. So they want to start in a different way from the CMA by looking at individual states of mind. The tribunal then says it proposes to consider the market and the state of mind of all the relevant actors at various points in time. That's what it now goes on to do. But below that, in paragraph 93, you see the tribunal recording that it needs to find something crossing the line. And the tribunal goes on to say, in the second sentence, but in order to understand what crossed the line, the state of an actor's uncommunicated state of mind will be of considerable inferential assistance. If a given state of mind or intention did not exist, that may be suggestive of the fact that it was not communicated. So their starting point, as the judicial tribunal adjudicating on this, is let's try and ascertain the uncommunicated, the internal state of mind of the people who were involved on the ground. And so they're not referring to the primary importance of contemporaneous documents or conduct, which is what the CMA did, what the Bellamy Tribunal did. The tribunal says, look at the private mindset of the individuals. Having said that, the analysis which now unfolds does follow more or less conventional lines.
But the last sentence of 93,
Yes.
on the other hand, if a given state of mind existed on both sides, in other words, they pursue a common course, the inference of the communication crossing the line will be strong. So what they seem to be saying is, well, if you look at the state of mind on each side, and it's the same, and you then see that they've pursued a particular course of conduct, then there's a strong basis for inferring that there must have been some form of communication that crossed the line.
My lord, I entirely agree with that.
There's nothing wrong with that as a matter of analysis.
No, other than it's missing a piece of the jigsaw puzzle, which is that even if, say here, Mr. Baton did not intend to comply with this understanding that he conveyed with a nod
Yeah, I
of the wink,
understand.
even if it wasn't his intention at all in his uncommunicated state
Yeah, I
of mind.
understand that.
So let's now look at the analysis as it unfolds. The first thing the tribunal does is assess the commercial and economic context. That's page 459, internal page 64. And you look at heading 5, halfway down, the market in which Auden and Amco operated over time. Last paragraph at the foot of that page, you see which is 107. You see the tribunal starting with the first and unappealed infringing agreement. This is the so-called 20 milligram agreement made between Auden and Waymade in July 2011. So far so good, because that is relevant context. Over the page at paragraph 109, the tribunal notes that Waymade had commercial stock ready for sale, and it says, we do not know from primary evidence why Waymade chose to forsake its own route to market and sell Auden's product instead, but there is, as it seems to us, only one possible explanation, which it then goes on to explain, which is essentially that this is a deal to keep them out of the market. Over the page, you now go to the following page, 461, internal page 66. The tribunal next considers the later agreement, the 10 milligram agreement, with Waymade in October 2012. And it concludes in paragraph 113, just under heading B, that for exactly the same reasons that it articulated in relation to the 20 milligram product agreement, the 10 milligram agreement can only have been an agreement for Waymade to be paid to stay out of the market. All of this is, in my submission, unimpeachable. So having referred to the historical context and looked at the way the market works, the second thing the tribunal does is consider whether the undertakings which can only market the so-called skinny label products count as potential competitors to Auden with its full label product. And you'll recall that's one of the three key issues that need to be established in this case, the other two being a value transfer from the incumbent to the challenger and an understanding that the challenger is going to choose the supply agreement rather than independent market entry. So this point of potential competition is discussed in detail at paragraph 1153 on page 462, which is internal page 67. And again, I say unimpeachably. What they do in Roman 1 is say that we found using our market definition test that these are substitute products. But in Roman 2 they say, but market definition, that exercise doesn't really help with what we're doing here, which is a real world analysis. Roman 3, they get into how things work in the real world. And at Roman 4 you have the conclusion. In the real world, therefore, skinny label was not a non-competitor, but an unpredictably constraining competitor.
Is it appealed that they're competitive products, substitute products?
What is sought to be appealed by Mr. Really is the market definition analysis.
Right.
My point here, which I'm essentially trailing, is that you see from this structure that they begin in Roman 1 by saying the market definition, then they get away from it and drive into something else, which is a real world analysis. So it's not a point that arises. But you see, the way that they do it is unimpeachable because they explain that the skinny label isn't a non-competitor and how it works. And if you go over the page, Roman 6, Well, Roman 5 says we've looked at figures on the effect of actual market entry, which shows that skinny label has an impact. And then at Roman 6, we consider Auden would have been well aware of the dangers of multiple new entrants, and in this case, the dangers of a single new entrant selling an inferior skinny label product. Averting this danger to buy off Waymade would have been worthwhile. So, for those unimpeachable reasons, it's reasonable, it's robust, they find that this is a case of potential competition. Next point, third point, the tribunal finds that Auden did make a value transfer to the challenger, AMCO, by means of the supply of the product in this way. And what the tribunal does is to set out Ms. Dimitriou's cross-examination on this point of AMCO's witness on page 443 of the bundle, internal page 48, paragraph 76. It sets out extensively Ms. Dimitriou's cross-examination on the value transfer, but all you really need to read at this point is the top two exchanges. Question, it's just under the heading, paragraph 76. Ms. Dimitriou, is that normal in your experience for one company to effectively transfer a lot of its profits to another company for nothing in return? And Mr. Baton's response, I thought it was very odd, very odd. So the point is that Mr. Baton is accepting at the outset that these are very odd terms, and he says near the bottom of this page that it's a gift horse. This is in his final answer at the bottom of that page, second line. In my opinion, it was, though obviously to use your words, Sir President of the Tribunal, it was a gift horse I was presented with. Generally, his evidence was that he didn't concern himself with what was in Auden's mind in offering this deal. And that is a feature which is picked up in this judgment, which the tribunal does not accept. One reference is on page 445. The top, you see again Ms. Dimitriou's cross-examination on page 445, internal page 50. You just look at the first question and the first answer. Mr. Baton's answer is, I gave it thought, I didn't speculate. I asked Rob to sort out the agreements to make sure they were legal because it just looks a bit odd, but apparently it was. Nonetheless, Mr. Baton suggests in his witness statement for the appeal, his written statement, that Auden might have entered into the supply deal on these odd terms to ensure that it got higher manufacturing volumes. And on that, Ms. Dimitriou challenges the rationalisation given by Mr. Baton in cross-examination from the witness statement. So if you look at the top of page 444, internal page 49, she puts to the witness at the top of the page that in this particular case, Auden couldn't have been looking to increase its volumes because it's the only show in town, it's the only supplier in the market, and so Mr. Baton's explanation doesn't make any sense. You look at the second and third questions from Ms. Dimitriou at the top of the page. First one, in fact, it wouldn't make sense, would it? And she pursues it by saying, so what you're saying is just purely hypothetical. And the witness agrees with her. You look at his penultimate answer at near the foot of the page. Sorry for Auden's conduct, no, I agree, sorry. So he accepts that the rationalisation he's given in the witness statement is wrong. And then the tribunal reaches its own conclusion on this. And you see that at page 446 over the page, which is internal page 51. If you look at paragraph 78. Here the tribunal is criticising the witness's answer. And you'll recall at the end it's finding the witness dishonest. But it says here, you can appreciate entirely that every sensible businessman would not wish to offer in payment more than would be acceptable to the counterparty to achieve a deal. But, as we've emphasised a number of times, Auden's conduct is simply impossible to understand, and Mr. Baton's rationalisation does not come close to explaining Auden's willingness to accept so low a price, concede massive margins. This, we consider, would have been obvious at the time to Mr. Baton, as indeed he conceded in Cross-Ex. It follows that Mr. Baton was either himself offering more on AMCO's behalf, something he denied, or he should have appreciated something was going on within AMCO requiring close and careful explanation. The tribunal also says separately that it can't accept Mr. Baton's claim that Auden's thinking was irrelevant to him. And you might not have picked this up on the read-through of the judgment because it's in a footnote. So you have to go to page 451, a few pages on internal page 56. There's a very long footnote which actually begins on the preceding page. But if you look at the second paragraph down in the footnote on page 451, they say, second sentence, we have the following points of concern. One, although Mr. Baton asserts that Auden's thinking was irrelevant to him, that's not the way commercial businessmen negotiate. They seek the best deal from a close understanding of the other side's thinking. And Mr. Baton, in fact, impliedly asserts that both parties were negotiating on the basis of a contract manufacture organisation agreement. The reasons we've given, this will not have been Auden's stance. To equate the value provided by Isaga, contract manufacturer, with the value provided by Auden is incomprehensible. Isaga were manufacturing a product for AMCO to sell under its skinny label. Auden was supplying a ready-for-sale product under its MA, which is full label. In short, there is no proper comparison. So this is a second part of the judgment where the tribunal is saying, I cannot accept what Mr. Baton has said, that the thinking of the other company was irrelevant to him when he sat down.
Well, he returned to that in paragraph 124 on page 466.
Yes, he does. He does.
That's the paragraph. I mean, that paragraph which particularly struck me because it's effectively saying, well, that Auden's conduct was completely idiotic or incomprehensible unless they were getting the quid pro quo, as Mr. Baton denied they were getting. But the point the tribunal is making here is they must have been getting something in return, and something in return was staying out of the market.
Yes. No, absolutely, my lord.
None of which has got anything to do with dishonesty or...
No, it does not. I agree with all of that. To round off the observation I was making, which then does lead through to this, there are two respects in this judgment, which we've now covered, where the tribunal is particularly critical of the witness. We've now covered both of those. This is really by way of just trying to understand the finding he then makes at the end, that the witness was dishonest and he's found it. Where he could have got that from. Those two seem to be the only parts of the judgment, I'll be corrected, where he actually he says the witness cannot have been giving us accurate evidence. So we've covered the legal and economic context, including the 20 milligram agreement. The tribunal took that into account. We've covered potential competition, shown that the tribunal took that into account. We've covered the value transfer, that there was an uncommercial bargain. The fourth point then, and this now comes to my Lord the Chancellor's observation directly, is the tribunal reasoning that there's the last piece of the jigsaw, a common understanding between Auden and AMCO that the value transfer is the alternative to market entry on its own account. And that's where we go to paragraph 124. And the reasoning, as my Lord says, is, in their judgment, it's not something that they would have entered into without getting something in return from AMCO to justify the commerciality of the transaction. In short, we consider the inference that there was something more to the 10 milligram agreement to be quite overwhelming at this point in time. So, yeah, absolutely, this is how they are reasoning. They've looked at the earlier contextual agreements, the history. Now they look at this one. They disbelieve Mr. Baton in two respects in relation to the evidence he's given about what was going on. And they say this is our inference as to what was actually happening at that point in time. The tribunal then supports this point that Auden can have been expected to want something in return. If you go forwards to paragraph 134, internal page 81, bundle number 476. So this is now paragraph 134, and there are two references in it that I'll pick out. The first is in paragraph 1343, the large paragraph, subparagraph at the bottom of the page. This is underlining the point that the skinny label producers were potential competitors, and they would have been a worry to Auden because their entry could have led to a major erosion of prices. You see that if you see the second line up from the foot of the page, but in those terms. And then if you turn over to subparagraph 4, page 477, internal page 82, here the tribunal in its reasoning is expressly relying on the context of the 20 milligram agreement to draw inferences as to Auden's state of mind in relation to the later 10 milligram agreement, because Auden was a party to both of them. And you'll see this halfway down. The tribunal says, we do not consider that there's any other inference possible than that Auden was paying Waymade considerable amounts of money in order to receive something in return. And just above that, just to ensure that the remark in the sentence above is not lost, in this judgment, referring to the earlier agreements, the 20 milligram and the oral 10 milligram agreement, and the first written agreement, the tribunal says these agreements all have the same essential purpose. It's wrong so narrowly to pass the course of conduct as to leave relevant material out. So at this point, correctly, in my submission, they're taking it all in the round and looking at the cumulative impact of all of this together. Now, that's Auden's state of mind. Yeah, that reminds it in subparagraph 5, just for completeness. They go on to say this. We consider this was exactly what happened when Waymade obtained its 10 milligram agreement, and they say that it can't be a coincidence given the timing parallel with the 20 milligram agreement. The purpose was exactly the same.
When the court's trying to draw inferences, you do precisely what the CAT did here. You ask yourself, is the conduct commercially logical? Is it a coincidence? And if you have a solid body of evidence from which you infer that there is only one sensible conclusion because otherwise it's just not rational or it's not coincidence, that's a fairly solid basis upon which to draw an inference. And that's what the CAT has done here from facts which are, they conclude, largely incontrovertible. It's inferences they're drawing from them.
My Lord, we agree, and this is why, for our potential respondents' notice, we say that on this part of the case, the CAT's reasoning is robust. Yes. Yeah. Now, the tribunal, so we've looked at Auden's state of mind and how they draw inferences there, in these paragraphs. They then turn to look at AMCO's state of mind on the other side of the table. Now you go forward to page 480, internal page 85.
Yeah.
So they actually say, as far as I can work out, and they're talking about Auden, but they say there are no documents and we haven't taken them into account. They're not the basis of our conclusions in 135 first bullet.
Yes, in relation to Auden's state of mind, yes. And my Lord, I'm grateful to you for picking that up, because part of the theme of what I'm saying is you see a very different approach taken in this judgment from what the CMA had done before, which was working through a group of contemporaneous documents. For the reasons given by my Lord Justice Green, our case is this is a robust approach that's being taken here, but it's not the same as the approach that the CMA took in its decision below. The tribunal then is looking at AMCO's state of mind. So if we go forward to 141, paragraphs 141 and 142 on page 480, you see that they say that ordinarily that they would approach the question of knowledge and state of mind in a chronological order, but that's not what they're going to do here. They say that they're going to start with the second written agreement, and if you look at the last sentence of 142, we will then consider what our conclusions in relation to the second written agreement tell us about what went on before. So, to pick up something which I think is mentioned in Miss Ford's skeleton, it's a sort of reasoning backwards from the hard evidence that they heard cross-examination on relating to the second written agreement. But they say we're going to consider what our conclusions tell us about what went on before. And that is despite the fact that AMCO takes over the oral agreement from Waymade through Mr. McEwen, who negotiated both the 20 and the 10 milligram agreement, and there's an 18-month period which is not accounted for. The key points in the tribunal's reasoning here can be seen from paragraph 144 at the bottom of the page, where the tribunal explains its reasoning in relation to AMCO. Now, I do need to say at this point that some of these specifics here are, in my respectful submission, unarguably contrary to the evidence and essentially perverse. And I will come back to what the tribunal said in particular about AMCO being in no position to obtain alternative supplies to Auden, which it does. But the key findings supporting a common understanding, they are robust. If you look over the page at 481, look at Roman 4, last subparagraph there, the tribunal is making the point that it would have been very risky for AMCO to market its own skinny label product. And they talk about being aware of the problems that this would have brought because of the reduced indication. Then over the page at 482, near the top, in subparagraph 4, 144, the tribunal asks itself, well, what negotiating leverage did AMCO have with Auden? Below that in subparagraph 5, you have this. We decline to accept that Auden would have concluded the agreement without something more coming from AMCO. And then in subparagraph 6, foot of the page, you have the important conclusion. It says the one card of any value in AMCO's hand would have been, and in our judgment was played. This was the threat of alternative entry by AMCO into the market, which Auden was prepared to pay a steep price, essentially to avoid. If I stand back, pause for a moment, the court has already seen that this threat is recorded in the contemporaneous documents relied on by the authority to which the tribunal isn't referring here. And you've also seen that Mr. Baton accepted in cross-examination by Mr. Mitriou on those documents that he did make the threat, and he accepts the implication based on the threat. Yeah. But those elements of the witness evidence under cross-examination before the tribunal, those are also not referred to here. Nonetheless, the reasoning is, on the basis of the market context, essentially, you can only explain what happened on the basis that this card must have been played. Now, if you go forward to page 483, internal page 88, next page, subparagraph 8, you get a paragraph which has been the source of submissions for this appeal, because here, in subparagraph 8, the tribunal makes certain findings that go beyond the CMA's decision and which in our submission are unnecessary for its conclusion. It infers first that there was a conversation, as you can see, first line, between Mr. Patel of Auden and Mr. Baton, at which an agreement was reached about staying off the market. CMA's case is that in the light of Mr. Baton's threats to enter, if the terms weren't agreed, an agreement that AMCO would stay off the market if acceptable terms were agreed was at least an unspoken common understanding of the parties. The point is, from the perspective of enforcement by the authorities or by the courts, you can never precisely know. But that does not matter. What is clear from the contemporaneous evidence as a whole is that AMCO, what they said and what they did, both before and after the supply deal, was consistent with a common understanding. Mm-hmm. The second inference made by the tribunal in subparagraph 8, staying with that, at the foot of internal page 88, page 483, is this point that there was a conversation at which AMCO would not only stay off the market, but you'll see what they say in the third line, but would take Auden's product and sell it at around the prevailing market price. Now, if you take that at face value, it's difficult to square with the tribunal's own statement only 2 pages on in the judgment. You look at page 485 at the top. That's internal page 90. And you'll see at the top of that page, the last few lines above paragraph 148, that here the tribunal's dealing with the pre-existing 10 milligram agreement before Mr. Baton gets involved. If you look at the last 2 sentences, see what they say. In short, it would have been important to Auden to maintain a high price across the market. We consider that such a common understanding would have been an inevitable part of the arrangement, so obvious that it would not require express statement. We agree, and exactly the same reasoning applies to the arrangement after the second written agreement takes place in 2014, and that is why it's unnecessary to find that there was a conversation in which they actually said, we will charge prices at around the level you're already charging. We endorse the reasoning, the top of 147, just above 148, as eminently correct. Then, at the foot of page 483, if you just turn back, Roman paragraph 2, bottom of the page, the tribunal makes a significant observation. It notes that Mr. Baton would have bluffed to secure the supply deal, but the tribunal rightly focuses on what Mr. Baton conveyed or communicated to Auden, not what was in Mr. Baton's own private mind. And finally, and critically, you look at the top of page 484 at subparagraph 1449, the correctness of this conclusion, which we reach conscious that we must be satisfied to a very high standard, can be tested in this way. The one big difference between the first and second agreements was the increase in supply. Went up to 12,000 packs a month. What could Mr. Baton have said to induce Auden to agree to such an increase? Question mark. We consider there is only one plausible answer, which is the one given above. I'd like to dwell on that for a moment, because this is a passage that you'll see this tribunal seeks to gloss half a year later in the H3 judgment on due process. The tribunal there says that its question here, what could Mr. Baton have said to induce Auden to agree to such an increase, is framed as a rhetorical one, but was not meant to be rhetorical. In the later judgment, it says it was meant to suggest that Mr. Baton could have given an answer to it if only he had been asked in cross-examination. And that is, in my submission, a very hard proposition to understand for 2 reasons. first is the tribunal's final sentence here. You have it still open. In paragraph 1449, we consider there is only one plausible answer, which is the one given above. That's not consistent with saying if only we'd heard from him, we would have known. The second is that the tribunal actually did hear Mr. Baton's oral evidence about what he said, and I have already shown you a very clear extract from the cross-examination on this point. We've now discussed two key extracts.
But this isn't about what Mr. Baton said in his evidence. This is about what Mr. Baton, this is, as it were, a hypothetical question as to what he could possibly have said that would have induced the increase in supply, and they're simply making the point that the increase in supply was clearly generated by the promise to stay off the market.
Yes. In this judgment...
It's got nothing to do with his evidence at all.
No. In this judgment, it appears to be saying there is only one...
It's sort of accepting, really, isn't it, that whatever he'd said in his witness evidence wouldn't have made a blind bit of difference, because it's the obvious explanation.
Yes, exactly. But then when you come to the later judgment, he's saying, no, that's not what I meant. What I meant was if only we'd asked the witness, we would know. And those two propositions are not compatible. So leaving aside the due process issues, which we've now already covered, the final conclusions of the tribunal on the grounds of appeal, you come to in the section which starts above paragraph 154, conclusions regarding the ground of appeal. It's on page 487, internal page 92, at the bottom. And you can take that very shortly. 154, the last but one paragraph, bottom of the page. The reasons we've given: we uphold the findings of cartel infringement in the decision. Over the page, paragraph 156, and you'll note here that the tribunal is referring to the fact that the 20 milligram agreement, part of a pattern of facts supporting the findings we've made. That's the fourth line down, where it said it doesn't need to. But the first sentence reads, all of the grounds of appeal fail in unqualified terms. And last, paragraph 1573 over the page. Last three lines, really, or the penultimate sentence. The CMA has made a decision which we consider, underlined on the merits, to have been correct. Despite those definitively framed statements, and indeed the definitive statement of the dishonesty of the witness, which my friends referred to, the tribunal says it's not in a position to finally determine the appeals until there's been further argument on the due process question.
Can I ask you just a point of it's almost public law. Assume for the sake of argument that you're correct and that it was an error for the tribunal to conclude that dishonesty was relevant. When you get to the point of the judgment at 156, you've got all the grounds of appeal fail. So test the proposition thus: there is an error of law. What is the impact of that error on law, on its consequence, namely the holding of a second hearing?
If the error of law is the reference to the dishonesty...
Well, it's the reliance upon that. There may be arguments about what triggered the second hearing, but assume it's dishonesty, and they've made an error because they've assumed it's relevant, and you've established that it isn't. What is the consequence of that on the fact that the second hearing then proceeded upon the premise of an error of law?
My Lord, I'm very grateful to you for raising that, because it enables me to round this off. For the reasons that I've just been developing for the last while, the conclusions upholding the CMA's decision don't touch the dishonesty point. They're inferential. You look at the market context, the history, and so forth. They reason that there can only be one plausible answer, but dishonesty doesn't enter into it, and that is why we say that the conclusions that you see here are safe. Now, we agree, and it's our case, that dishonesty should not have been part of the thinking of the tribunal at all. and that the way that it dealt with it was an error of law in this judgment. But it is not an error of law that infects the central process of reasoning that led to the upholding of the CMA's decision.
Well, that's why I'm saying you get to 156, and if you're correct, that that's not based upon dishonesty, it's based upon inferences from primary facts of which it was certain, then it then proceeds to say, right, we're going to have a due process hearing. That arises because, on this hypothesis, there was an error of law. I'm simply saying what, almost as a matter of procedural law or public law, is the consequence of doing something which is predicated upon that error of law, namely that we've now got to possibly qualify our clear findings because we've got to get into a due process point on the assumption that dishonesty is relevant.
Yes. And that takes me to the second part of our case, and indeed to the basis for the CMA's appeal, which is that the error which then led to the further hearing and ultimately the H3 judgment in March this year were matters that were themselves wrong, and it is that process and the judgment that emerges from it, the H3 judgment, with its conclusion that because of a failure of due process, the earlier decision should be essentially reversed. That is wrong, and that is the part that, viewing this through the eyeglasses of public law, falls to be excised. But what remains is the findings based on unimpeachable reasoning in relation to upholding the CMA's decision in H2.
Well, why shouldn't we read 2 and 3 together? 2 is expressly made, caveated by reference to the due process point, so that when you read 2 and 3 together, you you have to disentangle what you say is right from what is wrong, but there are errors in the tribunal's reasoning on your case as to the relevance of dishonesty, and surely that means that the decision can't stand on either basis. I mean, there are findings you say that are unsustainable on the evidence. There are the mistake about thinking dishonesty is relevant. The whole thing has to be looked at, I would have thought, together, because they say we're not promulgating this decision till we've heard the due process. So what's the effect of all that? How do we disentangle all that, if you're right? Send it all back to the tribunal?
No, my lord.
I noticed a bit
yes.
of error.
And it's not merely a concern for the public purse. The point, I think, can be put this way. The findings that were made to lead to the conclusion that the CMA got it right were based on a process of reasoning which is immune from, separate from, these dishonesty findings. The tribunal itself, the tribunal itself in this first judgment, and to get the paragraph at an early stage, says what we're going to do is proceed to make findings based on the evidence before us. We're going to give the CMA permission to appeal, but the reason we're doing this in H2 is this will stand as a record of our findings should it be said by the Court of Appeal subsequently that our thinking on the due process and dishonesty issues was wrong. First point. The findings, therefore, which they relied on to get to their conclusions, those were sound. In certain respects, there were mistakes, which I've said were not essential to the conclusions, because I pointed out that the central pillars of its findings were robust, reasonable, and unimpeachable in themselves. The second point is this. You say that one should look perhaps at these two judgments as one, point that Sinvan has made also in its case here.
Yeah.
What I'm going to come on, because I've now got to turn to the H3 judgment to show you, is a rather interesting but important point, which is that when you turn to that judgment, in various ways, it is not simply a seamless working through of the due process point. that has been trailed in the first judgment. It relies on different findings. It seems to forget in certain respects.
It makes inconsistent findings, doesn't it?
Yes, and it proceeds on a basis as to what the real problem was, which is not what it had said in the first judgment.
Yeah.
For those reasons, we say that that H3 process resulting in the judgment can and should be considered in their own right.
So just so I understand nuts and bolts of the process, what you say is that, and you're going to come on to deal with it now, H3 should be set aside completely. And that so far as H2 is concerned, the caveats about due process at the end of the judgment and the text that's put at the top of each page should be excised. Is that your case?
Yes.
So that the rest of the judgment stands.
Yes, that's right, my lord. I misspoke earlier. Ms. Mackersy pointed out. You can look at it now, in fact, because we're going to go to H3. But on page 307 of the bundle, right at the start of this H3 document,
H2.
This is the H3.
Oh, H3.
The H3 one.
Sorry, yes.
I wrongly said H2. This is the beginning of H3.
Yes.
In paragraph 7 on page 307. Look at the last half of that. There the judge is saying that the CMA must be entitled to contempt before the Court of Appeal, that it's wrong, and this is an explanation of why they went to the trouble of writing that first judgment in the first place. But we endorse that to the extent that what they do, what you see in H2, in the ways that I have walked through, is there is reasoning which fully supports the conclusions.
Okay.
The problem with all that, Mr. Turner, is that you have only appealed H3, but you have told us that H2 is wrong and unsustainable on a number of footings. First of all, the concern about dishonesty. Second of all, the findings that there was dishonesty, the finding that there was, I can't remember the other two findings that you say are wrong. But you haven't appealed those, but they have. So they have appealed them, and in answer to their appeal, you say they shouldn't have permission, even though the judgment's wrong, and then you put in a respondent's notice which raises the reasons why it's wrong, say. I mean, I'm assuming you have put in that respondent's notice to that effect. So we're left with a very difficult position. Either we uphold a wrong judgment, or we give them permission to appeal, give you permission to put in your respondent's notice, and put it all right.
Well,
how does that work?
So, my lord, the answer to that is this potential respondent's notice. If we could perhaps just look at that. It's at page. I can't believe the right reference. I'm sorry. In the core bundle, third volume, tab 16b, page 1459.
Yeah.
What we are
Yes.
Yes. What we are saying here is that the findings by the tribunal, which essentially I have walked through, are themselves sufficient to support the conclusions of the tribunal, and in true respondent's notice form, those conclusions can and should be upheld on different or additional grounds.
Yes, but I'm sorry, I don't think you're addressing my question.
Sorry.
We don't have any jurisdiction to look at H2 unless somebody's given permission to appeal it. You haven't applied to appeal, they have. So unless you agree they get permission to appeal, there are findings of dishonesty which on your analysis will be upheld when they shouldn't be. How do we deal with that?
Well, if
'Cause you
I
can't
understand,
fudge-
I
you
think I
can't-
understand your
You
logic.
can't fudge it, Mr. Turner. We can't fudge things as important as a finding of dishonesty against a person who gave evidence before the court,
Yes.
particularly not in these circumstances.
No, my lord, I see that. I think I understand the concern. If the procedure needs to be that they appeal against, as they've launched what they call contingent appeals against the H2 judgment. But if they are given permission to appeal against the H2 judgment, but it didn't result itself in a dispositive order, then in those circumstances we rely on our respondent's notice here for the proposition that the reasoning in the H2 judgment on central elements which led to its conclusion remains robust, and the conclusions in that judgment should be upheld for the reasons we rely on, which I have shown you formed essential parts of the tribunal's reasoning. They made clear findings on potential competition, the value transfer, and the giving of an understanding in exchange for
I
it.
suppose one way of looking at it would be this, would it? That to the extent that the respondents are seeking permission to appeal on the basis that there shouldn't have been any findings of dishonesty, then this court could say there shouldn't have been any findings of dishonesty, so to that extent they're right. But the essential reasoning of the CAT is not dependent upon the findings of dishonesty, which they shouldn't have made in the first place. I mean, that would be a jurisdictional route through,
Yes.
so far as this court's concerned.
No, but we have to give permission to appeal.
But we'd have to give permission to appeal.
We're
on
giving
that basis.
permission, we might be giving permission to appeal when we think all their grounds of appeal are rubbish.
Well,
How do we do that?
my
I
lord,
want to get to the
I'm
my
not
lord,
for closing argument.
yes, let's not run ahead of ourselves. However, we endorse what my lord the Chancellor has said. Essentially,
You can't, with great respect. I mean, it's all very well. My Lord the Chancellor's getting a pragmatic solution. I'm trying to get a procedurally correct one.
well,
And I mean, maybe the best thing is at 4 o'clock on the first day of this very lengthy hearing, you go away and think about it.
Yeah.
But I do think there's a serious point. I know it's good to have a laugh actually occasionally in the course of something so serious as this, but they have not appealed any of the points that you say are wrong, and you have not appealed any of the points. So you may want to consider whether you ought to file a notice of appeal. I think I gave you permission to do so. I think I said anybody could appeal anything they wanted on H2 or H3 except market definition. Well, subject to the caveat on market definition. So I think you need to consider that, because one logical approach to reach the Chancellor's solution is for you to have a notice of appeal which says this judgment's jolly good except for these 3 points.
my lord, yes, thank you. I
You've
won't take.
raised, sorry, you have raised your ground 1 of your appeal is in relation to H2, but it doesn't actually say that there was an error in relation to H2. And I'm not quite certain what your ground 1 is in relation to H2.
Which pages?
This is page 29 of Core Bundle Volume 1. I mean, you might amend ground 1 to raise the point.
But I don't think that's possible, because I know that we get into trouble with the CAT and orders, because we had this in a recent case where the CAT didn't want to make any orders, but I think here they did make orders on both cases.
At the end, not on. I don't believe they did after the.
Because if it were not CAT, I think we'd be saying, where's the order? But because it's CAT, we had an exchange with the CAT recently where my lord and I think all 3 of us perhaps.
I think the 3 of us, wasn't it?
I think we wrote to the CAT and said, where's your order? And they said, we don't do orders, get lost. And so we said,
Had it in trucks as well.
That's essentially what it did say.
And the truth was that they don't have under the rules to do orders, and the decision, because it's a tribunal decision in writing, can stand as the order, and it did in that case. So I don't think you get away with this by saying there was only one order made as a result of these two judgments, so that they are a whole which you have appealed.
My Lord, I accept that. Rather than taking this further
Think
now,
about it overnight.
we'll need to consider that.
Okay.
In the
15 minutes, let's look at H3.
In the 15 minutes left, shall we look at H3?
Yeah.
We nearly know it, finally.
Yes.
Right.
So you have this core bundle 1, for those with the hard copy, tab 10A, beginning at page 301. In overview, I'll seek to demonstrate 4 or 3 key points. Point 1, the focus in this judgment moves now away from dishonesty. As I've adumbrated, the central point now is a supposed failure by the CMA's counsel to put a central part of the CMA's case in the decision to the witness on the AMCO side, called by advance.
The hidden agreement.
No, it's not that.
Sham.
No. No, well, they've moved away from that sham, dishonest view. I want to show you they now say, and it is worth looking at it, the central part of the case, which is that there was an understanding that you'd stay off the market, that wasn't put. So that's the sharp disjunction. It's a really pronounced point, and it's very striking. 2, the tribunal presents an account of the CMA's case here, which gets it unarguably wrong in certain respects. Now, even going beyond this question of the side agreement, it differs in some respects from the account that they'd given in the earlier H2 judgment. 3rd point, and this is critical, the tribunal misrepresents the points put by the CMA's counsel to Mr. Baton in cross-examination and the evidence that was given by Mr. Baton. When you see it, one cannot understand how its conclusions were arrived at. So I begin with the first point, which is the shift in focus from the issue of dishonesty to a claim that the CMA's counsel failed to put an essential part of the case to the witness. But while we're here, I should say as a preliminary remark, I'm going to show you that there was a shift. I want to show you something that may explain it. If you open up in supplemental bundle 6, the hard copy bundles, tab 30, go to, in the supplemental bundles electronically, page 2535. So you have tab 30. It's tab 30 in the 6th volume of the supplemental bundle. Your Lordships know that the tribunal left H2 and said we're going to have a further hearing. In the written submissions ahead of that hearing, which are in this tab, tab 30, the CMA's counsel, then represented by Mr. Jones, went into the question of dishonesty and what must be shown, and said that in a competition case, you just don't get into these questions. And if you look at paragraph 41 at the foot of page 2535, and see what his skeleton said, turning to the competition law context, the question of whether and in what circumstances market fixing involves dishonesty has caused considerable debate. In 2 cases handed down in 2008, the House of Lords considered the circumstances in which cartel conduct would constitute the criminal offence of conspiracy to defraud. Those were the Norris and Goldshield cases. The more detailed discussion is in Norris, but Goldshield is particularly interesting because the allegations in that case have a lot of similarities to findings in hydrocortisone. In summary, it was said that pharmaceutical manufacturers had conspired to defraud the Secretary of State and others by fixing and maintaining the price and manipulating the supply of certain antibiotics. The House of Lords held conspiring to manipulate price and supply is not by itself a conspiracy to defraud. For that, you'd need an additional aggravating factor. Dishonesty could be that factor, but secrecy and deception by themselves would not suffice to establish dishonesty. For that, you'd need to point to lies and positive deception. See the discussion of Norris and its application in Goldshield. So without taking up time on this, what happens is that the CMA explains to the tribunal at that point, here are the authorities on how dishonesty works in this field, and two decisions of the House of Lords. I think it's the Court of Appeal in Goldshield.
No, it is House of
No, it's House of Lords as well, I'm sorry. And it's in the light of that that you then get a judgment which changes gear. And it changes gear, to answer my Lord the Master Rolls' point, by now focusing on an allegation that the central finding in the decision being the understanding that state of the market was not put. If you start at page 306, on that's internal page 6, my Lord, you're still using the internal numbering, and look at paragraph 4 at the foot of that page, you'll see this. The judgment, cartel infringements, was provisional because the tribunal was concerned that a central aspect of the decision, indeed what we consider to be the central finding of the decision, but which the CMA contests is not, was never put to the two witnesses called by the appellants, Baton and Sully. The tribunal never heard what they had to say about this central finding. They were available to answer questions. They were cross-examined by the CMA on a range of other matters, but not this one. So tantalisingly, what is this central matter? Go forward to page 329 of the bundle, which is internal page 29. Paragraph 38. Get this. If serious allegations are to be made against a party who's called as a witness, they must be both fairly and squarely pleaded and put to that witness in cross-examination. Serious allegations include allegations of dishonesty. The rule is not limited to such allegations. In this case, the allegation of involvement in the cartel infringements was a serious one.
Sorry,
even if
I'm not with you. Which paragraph?
I'm sorry, it's 38 in the middle of page.
Okay, thank you. Got it.
So I'm picking it up from the third line down.
Yeah.
The rule is not limited to such allegations, dishonesty.
Yeah.
In this case, the allegation of involvement in the cartel infringements was a serious one. It's the involvement in the cartel. Even if it did not involve an allegation, express or implied, of dishonesty.
Footnote 51.
And then if you go to footnote 51, bottom of the page, as is well known, infringements of Chapter 1 require no state of mind at all. However, establishing the fact of such an infringement may oblige the putting of allegations of some seriousness. So you can stand back and see.
Sorry, where's that?
Oh, this is
In
the
the
footnote
footnote.
at the bottom of the
Oh,
page.
the footnote.
I'm sorry. Yes, bottom of the page.
Yeah.
So you can see from this that there's a reversing of gear. Now it's the seriousness of the allegation inherent in involvement in the cartel infringement that is now coming into focus. Go to page 316, go back to that, internal page 16, look at paragraph 21.1. This makes the point that the CMA needs to justify its decision in an appeal on the grounds which are set out in the decision. Can't go beyond it. And if you drop down to footnote 16, because often in these judgments, important points are in the footnotes. Look at the bottom of the page. The appellants contended that the CMA in closing effectively sought to resign from the Hydrocortisone decision, because they were saying, you're now saying it's not based on dishonesty or sham. We can see why the appellants made this contention. For instance, the description of the first and second agreements as shams was one the CMA sought to reframe in closing. And they read on, we do not consider this point to be relevant. Don't consider it even to be relevant. The fact is that the Hydrocortisone decision made extremely serious findings against the appellants, which needed to be put to the witnesses called by those appellants. It is the failure to put essential parts of the decision that is the crux of the due process question. It is on this that we focus. So the tribunal refers to the company's arguments that the use of the word sham in the decision was tantamount to an allegation of dishonesty on the part of the individuals. But now, rather than endorsing that as the gist of the case, along the lines of the H2 judgment we've gone through, the tribunal says this is not, it says in terms, we do not consider this point to be relevant. In the final sentence of the footnote, it recasts the real due process problem now as the failure to put essential parts of the decision. The residue of the dishonesty point is there, and that is a claim that evidence given by the AMCO witnesses in the witness box at the trial needed to be challenged directly as essentially lies. And you get that if you go to page 384 of the bundle numbering, which is page 84 of the internal numbering, and look at paragraphs 131 first and then 133. So 131, you've got that page. We consider that had the CMA put its case to Mr. Baton, it would inevitably have had to allege dishonesty on the part of Mr. Baton. That much is clear from the following passages in his evidence, written and oral. So this is for the hearing, essentially. Mr. Baton denied the existence of the collateral understanding in terms. 2, Mr. Baton repeatedly asserted AMCO would enter the market as soon as it could. 3, Mr. Baton denied the existence of a value transfer in the sense of a sham payment from Auden to AMCO. So those are the things, the evidence given by him at the trial, which are now the residue of dishonesty. If you go to 133, had such a challenge been made, we have some difficulty in understanding how the CMA could have said anything other than that Mr. Baton's stated intention that AMCO would enter the market as soon as it had a deliverable product was anything other than a lie. Mr. Baton was positively asserting his belief in the state of affairs, fundamentally inconsistent with the decision. The only reason we find an allegation of dishonesty was not made was because the topic was not cross-examined on. Mr. Baton never had any chance to refute the implicit allegation of dishonesty. So standing back, the central point in this judgment now is the supposed failure by the CMA's counsel to put to the witness the serious allegation of the existence of a collateral understanding, as the tribunal puts it, something it refers to sometimes as a promise that AMCO would stay off the market. And the tribunal's perspective is that this understanding, which seems to involve a kind of covert side agreement rather than a shared premise for the supply deal, was an essential part of the reasoning. The tribunal says that there was a very serious failure to cross-examine on the issue, which has the result that the conclusions, which are now called expressly provisional in the H2 judgment, can't stand as a matter of natural justice. For that, if you go back to page 308, internal page 8,
Yeah.
two references. Internal page 8, paragraph 10.
Paragraph 10.
First full paragraph on that page. The provisional findings of fact in the judgment, the earlier one, are, because of the conclusions reached in this judgment, unsafe in the most fundamental way. We have found a very serious failure of due process, which renders the finding in that judgment not to be relied upon. And then over the page 309, or internal page 9, paragraph 14.1, the judgment, cartel infringements, upheld the findings of infringement in the decision and found that all the grounds of appeal failed. Nevertheless, those conclusions were expressed to be provisional because of a concern expressly articulated in the judgment that the CMA's conduct of the proceedings had so fundamentally failed to observe certain requirements of due process that the provisional conclusions on the judgment could not, as a matter of natural justice, stand. So that's now how it is put, and the tribunal states that the existence of a collateral understanding, that is, we will stay out of the market, was denied in terms by the AMCO witnesses at the trial. And you see that if you look at paragraph page 312, paragraph 19.5. The point, it's the last but one sentence. They denied in terms that the collateral understanding had ever existed. So it is that issue. Was there a, what the tribunal calls collateral understanding to stay out of the market, or was there not? The subject matter that the tribunal says was not put to the witnesses, leading to the failure of due process here. And as you've seen from that earlier footnote, the tribunal's now not saying it's dishonesty. We do not consider sham to be relevant. Now, it's the failure to put the central. I'm sorry.
Or intention.
Yes, or intention.
Which were the two things which triggered the further hearing or the concern in H2.
Yes.
Well, hidden agreement, sham and intention, failure to put dishonesty triggered the new hearing. Yes?
Yes.
And when it comes to the new hearing, what they are concerned about is failure to put the case that there was a covert understanding
Or collateral understanding.
or collateral agreement or understanding. But is that not sort of roughly the same?
It's not, my lord, because this idea of covert, this idea of cover-up being the engine for why there's a failure of due process is no longer there. Now it's, you understood, you conveyed an understanding that you would stay out of the market in exchange for the money. That was essential, it was key to the case, but it wasn't put. The witnesses were cross-examined on other things, but not on that.
Yeah, okay.
And if you go to page 315, that's internal page 15, look at subparagraph 13 at the top of the page, you can see it a little bit more clearly. So this is within paragraph 19. And you'll see, if you just read subparagraph 13 at the top of that page, in this judgment we focus on the evidence of Mr. Baton. We'll describe in detail how he was cross-examined. It's necessary to do so in order to establish the negative proposition that Mr. Baton was not cross-examined on the critical question of collateral understanding. And importantly, the tribunal says that if the case had been properly put to Baton, you see in that same paragraph, but not to the other witness, Sully, it doubts whether it would be deciding the due process question against the CMA. I am therefore going to focus now on what happened with Mr. Baton in my submissions in this appeal. That deals, in my submission, with the pronounced switch in focus of the tribunal's concern between H2 and H3 from dishonesty on either of those two bases to the failure to cross-examine on a collateral understanding to stay out of the market. My lord, may I just ask whether you're willing to sit to 4:30?
Not any longer, Mr. Tanner.
Not any longer.
No, absolutely not. I'm just wondering whether I've sailed past 4:15.
You've sailed past 4:15 because astonishingly and unusually, you had me interested in what you were saying. And, I wasn't looking at the clock, as judges so often do.
Right.
But, I'm afraid we can't sit any longer.
No.
But I do find what you've just been saying a little bit confusing. And I genuinely do. The trouble is there is an overuse of the word critical in both judgments. This is critical, that is critical, and you can't just pull out the word critical. I'm going to do a search overnight and find out how many times things are said to be critical, but I'm absolutely certain there are lots of them. And I think we have to be careful not to pretend at every stage in this case to have identified the core problem if we haven't. And it seems to be true there was a change of focus, as you're saying, but you really are going to have to address some submissions tomorrow on how critical that change of focus was. But ultimately, of course, it's perhaps the points you were making earlier today as to the substance. But if it is all about substance, then we have to then look at whether permission to appeal has to be given for H2. And if that's the case, then you need to address what I said earlier. But
can I just raise also this term, just so I can think about it overnight, really? Your answer to this, to what the CAT says in paragraph 1913 about what wasn't put about collateral understanding, that's effectively those references you gave us earlier on into the cross-examination at pages 26, 28 and 56 of day 3.
It includes those.
Well, I follow it includes those, yes. But I mean that's, for example, where it was put to him that the premise is that if Auden agrees to supply, then AMCO will not enter the market with its own product.
Yes.
So you say, well, that is clearly
putting the collateral understanding. Yes.
But dishonesty wasn't put. We've discussed that ad nauseam.
Yes.
The case that Ms. Demetriou understood she was arguing was put in the way that, if I can put it this way, not meaning any disrespect, competition lawyers would expect to put the case. But she didn't go for the jugular in the way that common lawyers might go by saying therefore you're a liar, don't accept what you say.
Non-competition commercial.
And that seemed in the first judgment to be the problem. And then in the second problem, the second case, it's a shift not to the dishonesty, you're a liar. And then you have to bear in mind, I'm sorry to bang on, but then you have to bear in mind my Lord's original point, which is there are two species of dishonesty. You came here to lie, didn't you, Mr. Bloggs? Which is the good old situation in the magistrate's court.
Yeah.
And the point that you actually are putting forward a dishonest case, which is actually rather different. So, okay, I think we have to keep all those things in mind. I said it was a simple case.
It's at least an interesting case.
Yes. Well, we'll reconvene at 10:30 tomorrow morning. Thank you all for your forbearance in all the interruptions you've had.
All right,